Okay, I think we're going to start up now. Good morning, everyone. Welcome. My name is Chaya, HR Director at Roth&Co. Today we have joining us Joel Greenwald and Jessica Shpall Rosen from Greenwald Doherty. We will be sharing their information at the end of this presentation. I know many of us have questions in regard to returning to work. What are we allowed to do? What are we not allowed to do? How will it affect the business? So many questions that nobody has ever had to deal with. And well, most of us have not had to deal with, I should say. And we have Joel here ready to help us answer some of these questions, Joel and Jessica. If you have any questions, feel free to send in your questions. We're going to try to get it to as many as we can. I'm sure many of your questions will be answered throughout the seminar. And then whatever we will try to get to at the end. And if we can't get to responding through the seminar, we'll try to get to responding after the seminar. But feel free, send in your questions and we'll do the best we can. And for now, Joel, go ahead, you have the floor.
Yeah, well, thank you, Chaya. Hope everybody can hear me okay. As you can see, I'm working from my home office, like many of you. I want to thank Roth&Co for inviting us. We're happy to try to share as much of this information as we possibly can. It's coming in quickly. And I want to thank all of you for joining and listening today. And I know that it's hard for a lot of people out there, and I understand that. We understand that. We are a management side law firm that only represents businesses in employment and labor law. So right now, as employment lawyers, that's all we do. We feel like we're giving everybody a weather forecast. Honestly, we don't exactly know what's happening day to day. We're projecting sun on Sunday and then clouds on Monday. Literally, the law is changing by the minute. And we're staying up at nights trying to learn about the legal changes, because some of these statutes that have come out in the last few weeks, many of you have dealt with them, were hastily put out. And there's, when legislation is drafted in that way, there's going to be a lot of vagaries and a lot of things that aren't clear. And so we want to do what we can here today to really talk about reopening and getting back to work. And in the crisis mode that we're all in and how fast moving everything is, it's just very important that you don't make rash decisions. Don't make decisions in a hurried fashion. I think that you need to be deliberate. Speak to your advisors, whether it's us or another lawyer or your accountants. I think some of the things we'll be talking about really have more bearing on accounting type of issues. And I think, you know, make sure that you do that, because it'll be a theme throughout the discussion today. Plaintiffs' lawyers, people looking to sue companies, are lining up right now. And they're going to be looking to sue all sorts of folks, whether it's nursing homes on the end of what you've seen already starting to happen, insurance companies for not covering work stoppage type claims, and ultimately employers for how they treated their employees. Just some house cleaning here, that this talk is really informational only. It is not legal advice. There's no privilege here. I think we're recording now, but we'll probably stop recording before any Q&As at the end. But just please don't hesitate to reach out to us if we don't get to your question, and we'll try to answer it as best we can at a later date. There's a lot of things that you may ask also that are really difficult, and we may not even know the answer now because things have been moving. Literally, we'll talk about the PPP for a little bit at the end. Some changes this past weekend. So, you know, we have to really keep up with the law and tell you what's going on. So let me also talk about the fact that we're understanding a lot of the legal issues in the context of the fact that there's really a political division in this country. And there's a dichotomy in the way people are approaching opening up for business versus safety. So some states are now beginning to open up non-essential businesses in the South and in the West specifically. Many states like New York still have shelter in place. And the federal government is itching to reopen, and obviously reopening is going to start happening soon here too. And there's also, over the past few months, I think you've seen some divide between maybe even the mayor and the governor, the city and the state. And that's going to continue too. So navigating these laws that are often in conflict, and some of the principles that are in conflict, such as safety, such as reopening the economy, which may conflict with each other. Sometimes the poor employer really ends up in the middle. I just want to also mention that I brought my colleague and valuable resource, Jessica Rosen, who's my partner, and she's going to be chiming in from time to time too. And I'm going to be asking her some questions because I want this to also not be just a monologue and make it into some Q&A internally as well. So with that, I want to talk about some preliminary issues, like companies that are continuing to reduce workforces and are beginning to bring back workforces. One of the things that we talked about a month ago or so is that when you're reducing your employee count, if you're reducing, let's say, them by furloughing layoffs, that was one particular set of issues. But what if you just decided that you want to reduce their hours or their pay, which many employers have done, and now maybe you want to reverse some of that. And we'll talk about reasons why you may want to reverse some of that. But both bringing people back from furlough, back from layoffs, getting them back to full time, those are all significant concerns because they all have slightly different elements. If you are continuing to reduce the hours and the pay of your workers, I want you to be mindful of issues concerning whether or not they're exempt or they're non-exempt, meaning they're entitled to overtime pay or they're not entitled to overtime pay. Simply speaking, because we're not going to spend a lot of time on that. If somebody is non-exempt and they're not entitled to overtime, then the major thing that we're concerned about if we're doing any sort of reduction or then an expansion is that we're not violating the $15 an hour minimum pay standard with that. So we're making sure that they're making at least $15 an hour. With people that are exempt, people that are not entitled to overtime, there's some different issues. So Jessica, you know, there's a minimum salary threshold for exempt workers. How does that play into this?
Well, it's really important to, so if an employee doesn't meet, so there's a minimum wage, an hourly wage for hourly employees, and for employees who are treated as exempt from overtime, for most of those exemptions, there's a salary threshold. For many workers in New York, the current salary threshold that they can't dip below is $58,500 in downstate, in most of the state. And so with that, if the employee's salary dips below that threshold, it would be hard to make the argument that they're exempt from overtime. But you know, if in that situation, an employee is not no longer considered exempt, you may need to do things like start tracking their time, right? And ensuring that they are no longer working overtime. I'm sorry, that they are now tracking their time and capable of calculating what the overtime would be.
Time tracking is actually something that is a difficult thing as workers start to telecommute, because a lot of workforces really were not equipped to track the time of their workers. They maybe had punch cards and swipe cards and clock-ins and all sorts of older technologies. You know, is it a difficult thing for businesses to make sure that businesses track their time? That the employees track their time?
Absolutely, because if you had a system in place, I had one client that said, we're locked out of our business and we use punch cards, and how are we going to figure this out? I mean, I think that there is software out there, but it's hard to roll that out at this time under this tremendous time pressure and economic pressure. So a lot of clients have just returned to an old school timesheet, you know, that an employee verifies their time manually. You know, and as I noted before, people who may not have needed to track their time before may now need to. And so it's also about getting in the culture of tracking time. And I think working remotely, you know, when there's an overlap between work and home and people who, you know, it's really important to make sure that that time is being recorded accurately.
Yeah, because if you don't have the time recorded, the burden's on you. And ultimately, it's an easy mark for somebody to say, I was working all these hours and I wasn't paid for overtime simply because I was working from home. And it's low-hanging fruit for a plaintiff's lawyer or the Department of Labor to eventually come after you and say that you didn't pay overtime. It's something that I think we're mindful of during the times where it's more peaceful, not just during the pandemic times. But I think that right now you have to be especially careful that you're doing it right. But it's doable. It's very doable. Then and if anybody has any questions about what a timesheet may look like, we're happy to help with that too. Now,
Joel, just to jump in for a second, you guys are mentioning overtime and exempt statuses and dollar amounts. It's also important to keep track of time now because of the COVID time and the CARES Act, and knowing what COVID time your employee is taking, so you could percentage the payroll and their salary weekly as opposed to monthly, which a lot of employers are doing either biweekly or monthly. We do our payroll weekly, and now we have to keep track of that time even more so than just the overtime pay and making sure that employees are getting paid accurately on that end. The CARES Act makes it even more confusing and more important to keep track of it to the T.
Yeah, well, that's, and we'll get to that because, and a lot of that has to do with people wanting forgiveness for their loans come time to repay their PPE, to make sure that they're really meticulously tracking the work, the hours. And we'll get into that as we go, but I think that's a good point. And then there's also other issues with people staying at home with leave, and Jessica probably can answer some of those questions as well. You know, with respect to bringing people back from furlough or bringing them back from a layoff, you know, there is a little bit of a difference. Just to quickly define those two things, they are a little bit different. When someone's on a furlough, they haven't really been separated from the company. There's a work stoppage and they just don't have a job, okay, to do at that point in time. A layoff, you've actually laid them off. Even if you told them it was temporary, they're probably separated from the company officially. So when you're bringing people back that are furloughed, it's usually a pretty easy process, or it's easier. But if you're bringing people back that are layoffs, that were laid off, Jessica, what are some of the pitfalls that you have to be mindful of, and what are some of the things that you need to be doing?
Right. So when you bring them back from a layoff, essentially you're rehiring them. And so it's important to be mindful of the types of documents you need to give employees and have employees sign. So for example, if an employer has an arbitration agreement with an employee, it would be prudent to consider having them re-sign that. You know, there's certain notices that are required to be given, including in many states and particularly in New York, what's called a Wage Theft Protection Act notice, where you're supposed to give that to an employee upon hire and any time their pay rate changes or other information changes, pay information changes. So it'd be really important to make sure that that documentation is in order. In addition, you know, if they were laid off and it was a short period of time, you know, you may have paid out their pay time off upon the layoff, but if not, you know, you need to consider whether that's something to restore. And in some jurisdictions, such as New York City, where we have the sick leave law, it's actually required that you restore them accrued time under that law. So it'd be important to just look at those issues and have a plan in place for how you're going to roll it out and ensure that the documentation is compliant with applicable law.
Well, now that we're talking about planning, let's talk about a little more now about the plan for reopening in general, okay? And I think that there are a couple of things that have to be factored into this from the get-go, okay? I think that it's important for companies to think about the plan and not just do it, because there's going to be a lot of concerns, and we're going to get into those safety concerns and otherwise. But who are the decision makers within the company? Who's making the decision? Is it somebody from HR? Is it an office manager? Is it the CEO or the president? You should have some level of comfort that there's a committee or a few people that are making these decisions, because somebody's going to have to be in charge of safety. Somebody may be in charge of the structure and the real estate. Somebody's going to be in charge of who to bring back and when to bring them back. And by the way, whoever is being recalled, those are significant decisions that you're all going to have to make. In other words, who is being recalled actually is really very much in the bailiwick of an employment lawyer. Okay, that's very much something that we think about all the time, because just like we think about, well, are you discriminating against somebody when you're deciding to fire them? Are you potentially discriminating against them when you are deciding to recall some people versus other people. So I think there are some discrimination issues that you have to be mindful of. Once again, I'm just trying to forecast what I think some of the pitfalls may be should you not do this right, and where lines of attack, because we haven't seen lines of attack necessarily in our jurisdiction so much. We're seeing some around the country and some different things, but I think that if you don't bring back people that think that they should be brought and they accuse you of discrimination, it'll be very similar to a failure to hire, or ultimately what a wrongful termination case looked like at the beginning, because they thought they were being temporarily laid off and they're not being brought back. Listen, it's unlikely you're going to be able to bring back everybody, and you're going to need to make some choices. You may not be able to bring back everybody all at once, okay? And obviously people are now bringing people back under some of the mandates of the PPP, which we'll talk about, like I said, towards the end a little bit. It's best if the decisions are as objective as humanly possible. What I mean by that is that they're not colored by personal opinion, because that's the easiest defense for a discrimination case. If you say something like, I'm bringing back the most senior workers, that's who I'm bringing back. I'm bringing back people that were my highest billers. I'm bringing back people that were my top salespeople in terms of numbers. The more objective I can make that argument down the road, the better chance I have. Well, I didn't bring back the people that were of this race, or I didn't bring back these people that were pregnant, or I didn't bring back these people because we weren't bringing back that whole department at that point in time. So the more objective you can make this, the better it is. But I understand a lot of companies are going to cherry pick and pick their best performers to potentially come back first. And I understand that. But if you don't have objective criterion like sales numbers, billing numbers, it's potentially problematic. Not that I'm saying you shouldn't do it. Listen, when you're doing a layoff in reverse, you may do the same thing. You may pick your lowest performers to get rid of. I'm not saying you can't do that, but you're not going to have the protection from a discrimination accusation if you do it, because they're going to say, you chose me because I was in this category. That's just the way these kinds of cases work. So what I would suggest, and I think your accounting firm, and if you have an internal CFO, could be helpful in making some helping you with some operational decisions, like, well, I have money to just bring back $400,000 in payroll at this point in time. My decision was based on this. This was the necessity for why I made these decisions. You know, having some backup confirming why you made the decisions, especially if they are objective, like I said before, then I think it's helpful. I will tell you the one biggest pitfall here is that you do not want to make your decisions based on a perceived risk. You do not want to make your decisions based on the fact that, well, I don't want to bring back my older workers, my people that are over 70 years old, because I fear that they're going to get COVID. I don't want to bring back my people that have underlying heart conditions or diabetes or breathing disorders because they will get sick and I want to protect them. That's really not your decision. Okay, we'll get to some of the issues that are related to that and things that are there, but that shouldn't be in your decision making. And there is some very clear language from the government to not do that. So I wouldn't do that at all. I would think that one thing you may want to consider if you're deciding who to bring back is bring back volunteers first, people that potentially are volunteering to come back. I don't mean volunteers, people that are working for no money. I mean people that are literally choosing to say, you know, I want to come to work. I don't feel afraid. You know, if that's the case. The downside of that, and there is of course a downside to almost everything I'm saying, okay, is that ultimately the problem there is what happens if nobody volunteers? Then you're in a position of forcing them. Or what happens if you're not ready for everybody and everyone volunteers? So, but I think you know your workforce, and that may be something you want to consider. We're now, I think, at a time in our discussion here where I'd like to dive into some of the safety protocols and policies. And that's those types of things, like the Center for Disease Control has some opinions, OSHA, the EOC, state and local authorities. Those are guidelines that we often in peacetime, or I'll call it peacetime, but 2 or 3 months ago, we weren't paying as close attention to these agencies like OSHA. Sure, we wanted to make sure that the workplace was safe. But, you know, whereas CDC and OSHA and EOC are issuing guidelines, the state and local authorities are mandating shelter in place and things like that. So if you're an employer, you've got to pay attention to everything, you know, to what those guidelines are, and they are changing. They're changing regularly to the point where some of them seem obsolete that only came out a week ago. Actually, that's really true. And so what we're doing is we have companies all over the country, and we're working with them on a reopening plan. And some of them, like I said, out west and in the south are already beginning to reopen. And I think that some people in New York are planning the same thing. So I want to talk about some of the examples from those agencies and otherwise, both from an agency's perspective, some of the guidance they've given as to some safety measures, but also some of the things that we've been seeing some of the companies that we're representing do that maybe make sense. So Jessica, I'd like it if you could run through some of, and I don't mean run so quickly, but really just give us some time on some of the safety measures that we're seeing both from the government as guidance and also from some businesses that are doing some practical things.
Sure. If you don't mind, I'll just quickly talk through some of the different agencies that are involved in some of these safety measures, because it's kind of an alphabet soup, and I think it helps to have that context. So, you know, the CDC is issuing healthcare guidance. You know, we all know what they're doing. They're out there looking at these issues from a healthcare standpoint, but they do discuss employer issues. And OSHA, which is the Occupational Safety and Health Administration, gives guidance on safety issues, but they really have some teeth in that they can fine employers for noncompliance. And there's also an anti-retaliation provision that if an employer takes action against an employee who makes a safety complaint, OSHA has the power to investigate it. Now, the Equal Employment Opportunity Commission, the EEOC, usually in peacetime, as to use Joel's term, addresses concerns regarding discrimination prevention, harassment prevention, and they've been weighing in a lot recently on certain steps that can be taken and the way those safety measures interface with the discrimination laws. And then finally, as Joel mentioned, the state and local authorities are really the ones who are enforcing the day-to-day decisions about who's an essential business, who's enforcing shutdowns. So Joel, you know, so having that in mind, we've developed some thoughts about safety measures based on looking at all of those provisions. So, you know, a lot of clients have questions about taking temperature, right? Do we take people's temperature? Is that effective? You know, how are you going to monitor other potential symptoms? And are you going to keep records of the monitoring? And then if someone does get sick, what are you going to do in terms of what steps are going to be taken? And I know this is a big concern, right? It's sort of like, okay, someone's sick, how are we going to figure out what the next move is? We're going to need to figure out how to clean, right? Make sure that the cleaning is proper. Contract tracing, like following who was in touch, who was working in close proximity to employees, monitoring their symptoms. You know, I think there's already a lot of discussion about potential physical modifications that will be made. For example, you know, if it's a client-facing position, are you going to put up a plastic screen, you know, between an employee and a client, right? Are you going to put in place other barriers or walls between employees where, you know, we've previously been focusing on these open workspaces, or is that a thing of the past? Possibly. You know, thinking even things like door handles, right, where the disease can be spread. Are we going to think of, you know, no touch, you know, wave your hand over a monitor and open a door types of physical alterations? There's other ones, for example, you know, engineering work that can be done, focusing on airflow through a building and recycling the air like they do on airplanes, thinking about how that's going to work and, you know, making sure that you're minimizing airflow through a building, or even using potentially UV lights. So there's kind of, to think about the buckets, there's, right, how are we going to screen employees? How are we going to modify the workplace and come up with, use technology to potentially mitigate the contact? And I think thinking beyond this is like, what is going to be the process? I think Joel previously spoke to this. Who is going to be a decision maker here? Who is going to be in charge, right? Because you have a whole new infrastructure you're going to need to roll out. And it's really important to know who's planning these, who's rolling out these impacts, and who's keeping track if that's going to need to be done. And then also when something happens, who's going to respond, right, if there is an employee that's ill. So I think there's a lot of considerations, and we've really given a lot of thought to how all these agencies are weighing in on these issues, which have legal, implications as well.
Yeah, I mean, thank you, Jessica. I think that was great. I think that you want to have a chief safety officer. Even if you're a tiny company with 10 employees, somebody internally needs to own this and do as much research as they can. Listen, there may also be a time beyond temperature where companies are doing COVID testing on premises, potentially with an outsourced nurse or somebody like that, or antibody testing, or the, what's happening in Europe with some countries is that people are going for multiple forms of testing, whether they be and COVID testing, the antigen testing that they have the disease currently, and then antibody testing, which is the new thing that's coming out in a big way, and them getting potentially a passport, an essentially, or almost like a driver's license they could get back to work. I know Germany and Great Britain are moving in that direction, and it's pretty interesting. So I could see that too. It's also very important that there be PPE and masks, and some of the low-hanging fruit. The agencies have talked about that. And listen, you want to make sure that there's some really other, steps that I think that maybe seem superfluous. Like, in other words, do you really need to have group birthday parties and big, large meetings? Maybe they could go virtual. They've been going virtual now for a few months. Maybe you need to keep them that way until everybody feels a little bit safer. And obviously you're going to have people that have different views of the virus as to whether or not it's a real thing, it's any bigger than the flu, or it's the biggest catastrophe ever. We understand all that. My big problem.
So for a second, if you don't mind if I jump in, I know you guys are discussing what you could and what you could do, and all the measures that we need to take to make sure employees are safe while taking temperature, getting if employers are going to give notices and people are going to have to sign off that they're okay and they're feeling well and they can come back to work. But I think a lot of the questions that are coming in, people want to know, what do they do if employees don't want to
Yeah, I'm going to get to that in a second, because I want to put that in context, because that is a big issue, and that's going to come. Just hold on for a second. I appreciate that, and I think that that's an important thing. I want to talk about that in a moment, because I want to put the context in there, which is that no matter what we do, we've got to be mindful of, and I'll get to that in a second. Just give me a second on that, because I want to give you some background to the reason that, and that's really a big question. So there's no question, and we see that all the time. So that's a major league question in this arena, is how do you staff your company if people are all going to be afraid to come to work? Because as you can see, it's kind of the alphabet soup of safety measures, where we don't have any clear direction as to what's necessarily safe for the employees and safe for the employers with respect to making sure that they're immune from liability for some of these things. What if people get sick at work? So that brings me to this, which is, I think you're at a situation here where, on one hand, if, by taking people's temperatures and potentially doing things with their privacy that we wouldn't do in their testing and stuff that wouldn't be done from a legal perspective, it was unimaginable a few months ago, and potentially making decisions about people's perceived symptoms and so forth, you do run the risk of being accused of disability discrimination. You do run the risk of being accused of HIPAA violations and privacy law violations and so forth. So there is a lot of that. But then on the other hand, well, what if an employee says that I got coronavirus because I worked at your place and you didn't take the proper safety measures? Okay, that's potentially even bigger exposure. Both of them have exposure, so it's almost like a wrongful death lawsuit versus a discrimination lawsuit. Pick your poison. Now, one of the things that's going on as we speak, because I think this could be defined better in 2 weeks or 1 week or whatever, but we don't have clear answers on this, is that if the government is protecting you from liability, well, what does that really mean? Because you're hearing things from the Trump administration and Kudlow about the potential for a liability shield for businesses, that businesses may not be held potentially liable if there is someone that gets corona while at work. Now, that's not the case now. Now, the other question really is this. You may ask, well, if somebody gets injured at work, that's what I'm paying workers' compensation insurance for. I thought workers' comp would cover that. But is it really covered? Someone gets the flu and you don't know where they get it from, that they didn't necessarily get it at work. Is that in fact a covered illness? So there's a big fight within the world of workers' comp right now as to workers' comp, whether it should cover it or not. There's been some states out in the Midwest, I know, that have suggested that workers' comp should cover healthcare workers and people on the front line and that kind of stuff. But it's going to be a difficult battle, and it's very unpredictable whether workers' comp is going to cover anything. The U.S. Chamber of Commerce has been doing some lobbying, now advocating for protection from negligence lawsuits by the government if certain safety guidelines are met. And that would probably be a welcome thing for businesses to know, hey, I got to do this, this, and this. And if I do this and this and this, I'm going to be immune from a negligence lawsuit. But right now, I don't have a clear picture as to the way this is going to be going. We really don't. So, you know, from where we sit right now, and Chaya, it's leading into your question, safety is of paramount importance. Okay, and I understand that we have to staff a company, but we also want to be sensitive to people's safety. So the other thing is that if people have disabilities, okay, or they, you know, the things that I talked about before, that they're maybe older, they maybe have some of these underlying health conditions that make them more likely to catch coronavirus and, well, actually to suffer more severe episodes of coronavirus, or they simply have a mental state based on maybe a pre-existing mental condition that coming back to work would be very difficult. I think that what we normally have in the context of disability discrimination is we have a reasonable accommodation type of narrative where somebody says, oh, I can't do that. Can I get an accommodation for my disability? Like typically, for example, somebody's hearing impaired. I'm talking about going back, I need this device to help me hear on the phone. Well, it's $200. I think that's a reasonable accommodation. It doesn't pose an undue hardship. But if someone's saying, hey, I can't come to work, now I'm not talking about somebody just being afraid of work. I'll get to that in a moment. But I'm talking about somebody that actually maybe has an underlying condition and they're making out that case. Well, Jessica, what's our thinking there?
I think you first need to consider, so the framework that would apply is you need to look for potential reasonable accommodations. If they do have a medical condition or, such as what we've talked about, I see there's a question about this as well. I think the first question is, can the job be done remotely, right? Because I think that that's going to be an increasing consideration here. And if for the last now 8 weeks people have been working remotely, then what's keeping them from continuing to do so? Is there a business reason why they can't? So I think that will be a major consideration.
Yeah, for 30 years beforehand, I've been seeing folks say, well, it's not reasonable for us to have our support staff working remotely. We can't do it. I think that argument as to that posing an undue hardship on a company, which is the balancing test according to the disability discrimination laws, is kind of out the window. And I think that we have to be sensitive to that too. And once again, Jessica, there are the potential here for perceived disability claims too, right? Now, how does that work?
Yeah. Well, if someone, let's say that an employee, the law wants to protect against some, unfair assumptions, what are perceived as unfair assumptions about someone's condition. So, can you go and say to your employees like, oh, well, you got gray hair, you must be really feeble. Maybe you're in a high risk. So we're going to not, treat you the same. We're not going to bring you back. We're going to force you to be out on an unpaid leave for longer, right? So this idea that even if a person may not necessarily have a disability or a medical condition, if the employer is perceiving them that way without giving them a chance to explain what they need, there can be backlash in that sense too, and potential liability.
And I think that goes back to what we were saying earlier about when you're making the choices of also who to bring back. It's not for you to make the decision that somebody is sick or feeble or whatever. Let them come to you with that. I think that that's important. Even if they suffer illness, you really can't make those decisions. That's opening yourself up to a discrimination lawsuit. Now, I understand that I'm preaching safety here. So now, going back to what Chaya was saying just a few moments ago, which is some of the staffing challenges, because what if, you have to operate a business and now you're deemed you're now essential or shortly thereafter you're going to be considered essential, or the economy is just going to open up and you're going to be allowed to operate as within certain parameters. What if someone's simply afraid to go to work, Jessica? They're simply afraid to go to work. We have concerns there, right? From a liability perspective too.
Absolutely. So just being afraid without an underlying medical reason or, disability reason, usually is not a good enough excuse. But I think you still kind of need to understand a little bit more about the reason, because it may be that the person doesn't have a disability, but maybe they're worried about they have a family member that has a immunocompromised situation. So it's probably important to kind of understand a little bit more about what the reason is. But in any event, if it's just kind of an unspecified fear, it's sticky. It's not there's not kind of a clear answer. I think that, a lot of employers, especially in the recent weeks, have just said, okay, you don't feel like coming in, we'll give you an unpaid leave of absence. We'll let you stay out. Now, we realize that it may not always be appropriate for the business, depending on the needs. So in some instances, it may be appropriate to escalate that to, a type, say, well, you've resigned then, but, that still carries some risk because, if an employee says, well, I'm afraid to come in because I don't think you're going to keep me safe because you haven't implemented enough safety measures, and you say, okay, then you've resigned, then suddenly the employee could claim that because they made that kind of comment or raised a concern about a safety issue, then they could try to turn that into a potential retaliation claim.
Yeah, and I think the retaliation claims are a real thing. And look, if you're putting people out on an unpaid leave, you could also let them know that there's no guarantee that we're going to potentially bring you back when this is all over. But once again, that carries some risk. We could see a lot of cases of retaliation cases, but honestly, once again, safety maybe, and the wrongful death issues and some of the things that we're talking about, make sure your operation is as safe as possible. And if somebody's actually out sick, what do we do there, Jessica? If they actually say they're sick?
Well, there's, you'd want, there are leaves available under the federal law and also state law for people who are out sick. There's pre-existing laws that provided for time off, potentially without pay, but now there's a pay leave component as well. And so there are certain things that the employee would need to, establish to be able to prove that they need leave. The bar has been lowered significantly in terms of what they need to provide, and it depends, the information they need to provide is going to depend on the type of leave that they need.
Yeah, it's a moving target. And I think that one of the things that we've also seen employers start to do is for folks that, and this is right now, of course, in New York and the essential businesses, is offering people a hazard pay. Okay, so giving them extra pay to come in, okay, because they have to still operate the business, and those folks fear what's going on. But once again, I think that, there's now beginning to be enough instruction as some of the safety measures that you need to take into account, having people keep it clean, wear masks, do what they need to do. So, I think we're getting some guidance as to some of the standards of operations for a company. Yeah, Chaya.
So Joel, just practically speaking, taking temperature is okay.
Yes,
I know that.
there's a lot of, it is the EEOC has issued guidance that it is okay to take temperature. I would say that, you know, if you want to email us offline as to some of the specifics of how to keep the records and some of the regulatory issues that accompany that, I'm happy to answer that. But I would tell you that technically speaking, as of now, yes, it is okay.
Taking temperatures is okay. Making employees, not recommending even having them wear masks and telling them that they cannot come into the office without wearing masks is okay at this time.
Absolutely. Absolutely. In fact, I think that's baseline stuff. You know, making sure
And
that
if an
you want to be providing, now that masks are a little more accessible, you may want to be providing the PPE. Now, also, you need to understand that if they didn't put on their PPE stuff yet, and that is work time. So we going back to the overtime thing, that's covered time. So time putting on safety equipment is paid time. Time taking off safety equipment is paid time.
Okay. And then if an employee does not want to have their temperature taken, what does an employer do at that point?
Listen, I'm sorry. You've got safety measures to take into account. The employees have to comply with it. They don't have to work for you.
Okay, great. Now, if an employee's, what about this document that a lot of employers are putting into place to have employees sign about their symptoms, about things that are going? If an employer sees an employee have symptoms, is it okay for them to send someone home because for their concern of their staff?
Look, I think, you know, it's another really great question, but I think that, you know, we're forecasting. Like I said, where the biggest risks come from. And in my opinion, safety is of paramount importance. And if somebody's coughing all over the place and exhibiting COVID-like symptoms, you send them home. Okay?
And another question that's coming up, I know a lot of people are having it. I myself at Roth & Company are having it. If an employee prefers to work from home, what's our obligation?
Look, I think that you should do whatever you can to make that work for the time being. I really do, because I don't think we know where this is headed. And if you can do it, do it. It puts you in a safer position. Okay, it's not just about the employee. Listen, a lot of businesses, you know, our law firm included, you know, we weren't having people that were supported, like secretaries and paralegals work remotely beforehand. It was attorneys did, but now, you know, they've started to, and it's working okay. So if it works okay, this isn't gonna, listen, this is not gonna be an indefinite thing. Let's hope not, you know. You know, it shouldn't be. Mirza Hashem, this will not last forever. So, you know, my feeling is that we just got to get through it, and we got to get through it in as safe as way as possible. And if some things seem incrementally less desirable, I got this call yesterday, or it was actually Sunday, from a client about, you know, well, we're an essential business, and they are an essential business for sure. But we think that some of these people are more productive these were office staff people, knowledge workers that could have easily worked from home. And so one of the partners is like, I want them working from home, it's safer. The other one goes, yeah, but I think they're incrementally more productive. We'll stagger their shifts if they come in. And I'm like, really, how much more productive are they? And shouldn't you be thinking about the fact that you have potential exposure here right now, especially in this window? Obviously, you know, nurses and frontline workers, that's a different thing. But for the most part, I think that you have to view things through the prism of safety more than anything else, not because that's an ideological bent I have. I'm simply saying that as an employment lawyer, because I think you need to put yourself in the best position possible to stay immune from liability. Right now, we don't have that thing that I talked about where maybe the government's going to give people a liability shield. We don't see that right now. Okay, until we know which way all this stuff is going to straighten out. And it may not be an easy lawsuit for someone to say that your safety measures were so poor. I know that there's been a few cases and litigations that have now emerged already in that. I'm not so sure how easy they're going to be to prove, but I'd rather my clients not chance that. And if it means incrementally less production with them working from home, I think you keep them at home. That would be the way I play it. Okay. if we could move on now to just talking a little about the PPP, which is the under the CARES Act, the Paycheck Protection Program. And I think the accountants from Roth probably have knowledge that exceeds mine on many levels when we're talking about the numbers. So I certainly would urge you to go back to them if you've got questions. But there are some implications from the CARES Act that I think really impact some of the staffing decisions that you're making now. And I got to tell you, talk about changes and confusion. There's the CARES, the PPP FAQ that comes out. It seems like every weekend, new questions come out trying to clarify it, and there's some shifting sand there. There really is. It's shifting also. But for the most part, these loans were devised primarily for smaller businesses, although you've seen in the press some larger businesses have taken advantage of it, and they put a thing in there that if you're somebody that is if you're somebody that really doesn't need the money, and what does that actually mean? But under FAQ question 31, they've suggested that you should return the money by May 7th. From what I've heard from the accounting community, who really kind of specializes in this more than we do, most people are not thinking that they know whether they need the money or not now anyway. But for the most part, the key thing that businesses are asking us about is that, well, we have staffing requirements if we want the loan to be forgivable, okay? And so what are the things that immunize or lessen the forgivability of the loan? And as far as I'm concerned, there's three main categories to think of it, and it's the simplest way to think of it, and nothing about these laws is particularly simple. But the way I would say it is this, is that at the base level, 75% of anything you're going to get forgiven for, if you're going to get forgiven for, let's say, rent and utilities, because the loan has to comprise payroll and payroll related expenses, including health insurance, and utilities and rent and interest on mortgages and things like that in one other bucket. Now, the payroll bucket has to be at least 75%, because this was a law that was enacted to basically get people back to work and to have people reemploy some of those people that they've laid off. Now, you have to spend that money on payroll in an 8-week period from the time you receive the loan. Okay, 8 weeks from the day you receive that loan. And then, you have to spend, if you want forgiveness, 75% has to be on payroll. So in other words, for example, if you got a $300,000 loan, and let's say you were only able to spend $200,000 with those predestined expenses like payroll, like rent. If you spend $150,000 on payroll, that would be okay, and then $50,000 on rent, then that may all be forgivable. And then you may be left with $100,000 in surplus that you weren't able to fit those numbers in, and that's going to be a 1% loan for you that I think will continue for approximately 2 years and has I think for the first 6 months, there's no interest. Once again, I think your accountants may know more about the particulars of that than I do. But the other two things that could also additionally lower your forgiveness is your full-time equivalents. And you need to have, and full-time equivalent is about an employee, and they add them up about 30 hours a week. And your full-time equivalents should be relatively the same between the time period you use to apply for the loan, and now let's just hypothetically say during a window within 2019. There's specifics, but I don't want to go crazy and make your head spin on that. But let's assume that within the time period that's being prescribed and now, between February 15th and June 30th, and you have time to cure this till June 30th. You potentially, let's say, go down from 100 employees, full-time equivalent employees, to 90 full-time equivalent employees, then 10% less of your loan will be forgiven. So in other words, in that situation where you had 200,000 of the 300,000 that potentially was forgivable, the example I just gave with the 75% payroll, now suddenly it's 180,000 because 10% less of it will be forgiven. Another thing is that it only includes salaries of employees that are making either less than $100,000 or really up to $100,000. So in other words, if you're looking at the payroll to make up that 75% that we want to keep the payroll numbers higher, if somebody's making $150,000 a year, well, only the first 100,000 is forgivable of their payroll, no matter what you do. You can lower salaries. So in other words, if you lowered a $99,000 employee by 25%, that would potentially be okay. But anytime you dip below, or it doesn't really matter, I just threw out a number, it could be a $50,000 employee, but you lower it by more than 25%, any amount you lower by more than 25% will also impact forgiveness. So you started with this mountain of loan that you got, and you could only spend so much to meet your 75-25 ratios, and then it's being chiseled away potentially at some of these other things, which is one of the reasons we see people now rehiring people to make sure that they get as much of this loan forgiven as possible. But from my perspective, that's an accounting decision very often. That's a business decision that I think you have to make it with your financial advisors as to what makes sense. I'm just interpreting the laws as I see them. We're not necessarily advising people from a business perspective on that. Okay, lastly, comments before we just a quick comment before we get to some more questions. I think, as I've said previously in this discussion, there really is a strong dichotomy between reopening the economy and the need for public safety. And I think that that's really a rub. It's a rub between people within families. It's a rub between certain states. It's a rub between urban and rural. Certain places have been hit harder than others. Either way, obviously many people think that we do need to reopen the economy, but we want to reopen it safely. It's important to think about that. But in the context of thinking about all of that, I think is now really the time that we want to be distracted by employee lawsuits. I don't think so. So I think that you need to really make your decisions with an eye towards that. That, well, okay, this may not feel as great as possible right now for me to do this, but I want to do whatever I can to avoid employee lawsuits, because I know that there's going to be a lot of people that the courts are closed now. The litigators are going to be looking to try to attack companies at a certain point. Let's leave yourself as pristine and as clean as possible. And I don't just mean the actual workspace being clean, but making sure from a legal perspective that you've done the right thing. So that's, I think, the end of our formal presentation. I guess maybe now, if you want to have some questions, maybe turn off the recording, because let people feel more, or whatever you want to do. But generally, that's what we recommend.
Okay. So a couple of questions that I see are a bit repetitive on our panel is a couple of employers want to know, they have some employees that are potentially making more on unemployment right now. How do they deal with something of that sort if they want their employees to come back to work?
Well, I mean, listen, what we're seeing is that there's some movement there that if, and by the way, New York's not completely settled on this right now. Certain states have now begun to request that if you're asking people to come back to work and they don't want to, obviously because they're making more on unemployment, that you may be notify the Department of Labor. And I can't necessarily think that's necessarily a bad idea here either. Jessica, any thoughts on that?
Yeah, I mean, I think in the short run, it might seem to employees like it's a better deal to stay out on unemployment, but ultimately that extra money from the federal government is gonna run out, and it's not gonna be the case anymore. And at a certain point, there's lots of people who are gonna want to be employed. So I think the key is, if someone's saying, well, I don't want to come back, is to document that you offered them the position. And if they choose not to come back, that potentially makes them ineligible, and then, move on to the next person and make sure you've documented that you offered it and they rejected it.
Yeah, and another thing, in terms of the PPP full-time equivalent issue, there was a decision that came out, it was an FAQ from the guidance from the Treasury Department that came out this weekend, that if you offered, in other words, you want to get that full-time. Remember I said that there's an example where you had 100 employees last year and now you only have 90 and you want to bring those 10 back, hypothetically, that you laid off, and you offer one of them a job and they don't want to come back, and you say, well, that shouldn't impact my forgiveness because I'm trying to bring them back. Well, the guidance is that you need to do what Jessica said. You write them a letter and confirm to them that, you know, we've offered you a job and you've refused it, blah, blah, blah. That should then not, according to the guidance from the Treasury Department, as we see it now, impact your full-time equivalent. Now, maybe you have 91 workers coming back.
You mentioned full-time equivalents. I know a couple of repeated questions of what is a full-time equivalent?
The full-time equivalent, as best we can navigate, and I hate to be so inexact, but that's just the way it is really somebody that's working 30 hours a week. And, you know, there's some cumulative things that are involved with that. So you've got a few different people, but we're looking for a 30-hour period of worker, okay, to denote somebody that's full-time equivalent. That's the way we're seeing it right now.
Okay. And question, I'm going to take a couple of questions from the panelists now. When does the 8-week period start for the PPP loans?
The 8-week period for really, when does the clock start running for forgiveness? That's really what it is. That's kind of the way you're looking at it, because that's what we're talking about. The day you get the loan, I think if it comes in an evening, it starts the next morning. So whenever the funds hit
the loan comes through.
Yeah, and one of the things that we've seen, and I don't know if you guys disagree with it, but we've seen also a lot of people set up separate PPP accounts and move the money over to a separate account and maybe reimburse their operating account as they pay expenses, something to that effect, so they keep good
For
book.
sure, so it's easily tracked.
Right, they can track it easily. That's, once again, that's more you guys.
Our employers want to know if they're obligated, if their employee came back and they had a positive test of COVID, are they allowed to request a negative test from their employee before they allow them to come back to work? I know there are some time periods and time frames, but with so much going on, we just don't know, and people are uncomfortable allowing employees to come back before they get that negative.
Once again, I'm going to give you a lot of leeway on this. Jessica, you want to touch that?
Well, I mean, I think that, you know, that is one possibility, but, you know, even having a negative test, right, is that enough? One thought we've talked about in our team, we're meeting every day to talk about these issues on our team, is to ask for a doctor's note clearing the employee to return, which is perhaps even better, you know, assurance that the employee is ready.
And maybe both together, you know, maybe both together, maybe even a negative test with a doctor's note. Listen, you know, we're because the last thing you want is somebody that comes in and that they've had COVID and then they're coughing all over the place and the other workers feel terrified. That's the quickest way to break down some of what's going on. So I think you want to feel as secure as possible, and getting some medical clearance, I think, gives some level of security, maybe even in addition to the test. And the tests hopefully are getting a little bit more accurate, but they're I mean, I could speak from a particular extended family member that some of the testing was ridiculous. So, you know, we've seen some real questionable outputs from the testing.
So basically, to be clear, legal guidance is we're allowed to have them test and ask them to test before coming back to work, before returning to work.
Yes, I feel good about that. As we said, that could change tomorrow, okay?
Obviously, things are changing so rapidly these days.
Yeah, Jessica, you agree, right?
Yeah, no, I agree. And I think, like, you know, there is a question. We have some clients that are in the medical field that have like tried to do the test themselves. And I think that there are you know, I think there are outstanding questions about that. I think a safer move is to ask the employee to, you know, get proof and to get a doctor's note of their own, to sort of keep that separation. But yeah, I agree with that. That's a good idea.
And I could see a situation very soon where there's a cottage industry that pops up in outsourced medical testers that come into workplaces, okay, and administer these tests, okay?
Right.
That I certainly see popping up in the horizon. For
well, we've already seen it. We've seen it. I know they're out there. I know people are coming. Health professionals are coming to the home to do it, and I'm sure they're ready and willing to come into businesses to do that as well.
I think it's, you know, you guys are in the know because you're on the cutting edge of the business community in Brooklyn, but I think that it's going to be widespread and even go into rural areas too.
Okay. some more questions from the panelists. A company that has employers that are kind of laying low, don't want to work, but when push comes to shove and they are able to reopen, and a lot of these businesses are going to be essential, how do they get an employee to come back and work and do what they need to do, as opposed to even some that are not filing for unemployment? They just, for whatever reason, is there anything an employer can do to, I don't want to use this word, but kind of force an employee to come back to work?
Well, there's no such thing as slavery anymore in the country. So making them indentured servants and so forth, I don't think would work. But I think we touched on this before. I think that it really has to do with, and as Jessica said, I think that, hey, those unemployment benefits may not last forever. I think if somebody feels at risk of safety, I think that one of the things that's important for you to have, I think from an internal PR standpoint, is not only do the safety things that we're talking about, but have a statement that says that's something to the effect of, hey, we have done everything the CDC recommends, we have done everything that OSHA recommends, and we have even gone above and beyond that, and the following things are some other steps we've done. We really think that we are operating a fully safe workplace, and these are some of the things, because maybe they don't even know what those measures are, and maybe you need to inform them as to how safe you're actually being, because I think that that's something, if you don't communicate it, how are they knowing that you're—
Sure. And right now, the obligation of an employer is to provide a safe environment. What does that mean for coming from the government right now and from all the institutions? What does that mean? How do we know we're following the right guidelines and making it a safe environment? Nobody wants to be open to all these lawsuits, and I know there's already one that started with Walmart, and there's some litigation going on where an employee did not feel like they were—
That's what I was alluding. Well, they were completely negligent. No one wore masks. No one wore PPE. But I think that, listen, there's some, we touched on, when Jessica and I went through that list, that included most of what was covered in the CDC guidance, most of what was included in the OSHA guidance, and then some of the other things that we're seeing there. Listen, one of the things that, if you want to give people our email up there, if people want to, email us for even some summary slides of this, and it has a list of some potential
that would be great.
vendors. I'm happy to do it, but email me directly and I'll be happy to send that out to you as to some of the things I see. But it's, and that list could change, because you know what? It is an entrepreneurial country, and people are thinking of imaginative ways to continue to up the safety standards. And I think that, taking temperature is something that is being talked about now, but I could see much more advanced testing, as we discussed a few moments ago, going to the workplace as standard going forward. So who really knows? But I think you have to, the government agencies that are giving the most guidance in this are the CDC and OSHA. Right, Jessica? Yeah.
Okay. So one more question regarding the PPP, and I think then we'll wrap up. A employer is asking, if they can't reopen until June and July, how do they get their PPP to be forgivable?
Well, that's a really good question. And not only that, but a lot of folks, and I think, like I said, I think you really should talk to your accountants about this too, because they interpret the PPP on some of these levels, maybe even in more detail than we do. But they're paying you to potentially have those people get some salaries. So even companies like restaurants are maybe bringing people out to consult the new menus and start to clean up the place and make it a better place, or work from home and not do all that much, but collect salaries. And what this really was designed to do was to keep people's jobs afloat, to get through this period of time. So even if they're not fully reopened, and there's plenty of folks that aren't fully reopened or aren't opened at all, that are taking the PPP loans and are paying people. But that is a decision that has some financial implications that I think you need to speak to your financial advisor about.
Okay. So just to wrap up, Joel, Jessica, I want to thank you guys for coming on. Thank you for all the information that you provided. I know it was definitely not easy to give some of these answers, and so many things will be changing and are constantly changing. Joel just put up the, somebody just put up the contact information for Joel and Jessica at Greenwald Doherty. Feel free to reach out to us at Roth&Co if you have any questions. I know we did not get to all the questions. We were not able to answer. We just unfortunately only have so much time that we can give right now, and the seminar is already over an hour, I see. But I want to thank everyone for joining us, and Joel, Jessica, thank you for being with us today.
Yeah, thank you so much. And our phone number, I think it's cut off. It says 212-644-1310, because I think our pictures are blocking it. And the email, as you see, is either JG or JSR, both at greenwaldllp.com. And feel free to reach out to us. We're certainly busy. And I want to really, once again, thank Roth&Co and Chaya for setting this up, and for everybody that listened. And stay safe, and let's hope we get back to work soon. Thanks.
Thanks,
Thank you
everyone.
guys for joining us. Have a great day and stay safe, everyone.